Hello YouTubers, hello world. I've just finished watching season 5 of The Crown. I hope you're enjoying it. I'm not necessarily going to do a straight opinion piece on The Crown, as much as I enjoyed it. Some very interesting bits and pieces in there that you may have missed, which I will bring to your attention, of course. But I want to do a video around my time within Liberty 963. Liberty 963 was a radio station on AM across London that I worked at in the 90s, in August 1997. It was owned by Mohammed Al-Fayed, and I was there, part of history, at the time. So the video is going to be around Diana's murder and why I think she was murdered. My experiences, my lived experiences, but I'm going to tell you why I do believe and think that. Also, I'm going to give you another Alex Belfield video soon, around my leaving of Century 106. Alex Belfield was the cause of me leaving Century 106, and me literally walking out live on air was my reaction to what he was doing, and more importantly, saying. But this video is going to be around YouTube whispers. I mentioned this before. YouTube whispers is where somebody says something and then other people believe what that person's saying. And one of my moderators has said, Adrian, somebody's saying that there's only 4 restraining orders in place, the 4 guilty verdicts. I said, no, that's not what the judge said. So, for those that are hard of thinking, thank you, Scotty McClue. Oh, and for somebody, I am going to mention in another video, but somebody said, oh, Adrian, you're a copycat, you're just copying one of Alex Belfield's sins. Go back to the video where I mention it, and you'll find I actually thank the originator. The originator was Scotty McClue, not Alex Belfield. I've told you before, Alex Belfield didn't have a single new idea in his head. It was Scotty McClue's and has been since the 90s. Oh, Colin Lamont, if you wanted proof that I know Scotty McClue. His real name's Colin Lamont. Scotty McClue is a figment of John Mayer's imagination. Anyway, let's get to YouTube whispers. So the person that thinks there's only 4 restraining orders for life in place? Listen to this. This is Mr. Justice Saini's judgment on the Crown's application under Section 5A of the Protection of Harassment Act 1997. So I may not be looking straight at the camera. I'll be looking at this to read this to you. In relation to the complainants in respect of the counts 1 to 4 where Mr. Belfield was acquitted, the Crown applies for restraining orders against him under Section 5A of the Protection from Harassment Act 1997. These complainants were Rosina Breen, Helen Thomas, Liz Green and Stephanie Hurst. Each of these persons gave oral evidence at trial. Section 5A of the 1997 Act empowers a court to make restraining orders against a defendant following his acquittal if the court concludes it is necessary to do so to protect a person from harassment. Nothing in this judgment seeks to cast any doubt on Mr. Belfield's acquittal. I am required to consider a separate question under the statute, which is the need for any future protection, even in cases where there has been an acquittal. That will require me to consider the evidence before the jury, but nothing I say seeks to question their verdicts. I am applying the civil standard of proof in identifying the facts, unlike the jury when determining the criminal charges. There were many common features of Mr. Belfield's conduct in relation to these complainants, and I will, in the interests of brevity, summarise my findings by reference to the common facts which emerged from the evidence. I will, however, also need to make reference in brief terms to evidence concerning particular complaints. In coming to my decision, I have taken into account the oral and written evidence presented to the jury. I also take into account that the nature of the future restraints which the Crown seek will interfere with Mr. Belfield's Article 10 of the European Convention on Human Rights, because they essentially seek to restrain speech and communications. Accordingly, I approach matters on the basis that the need for such future restraints must be convincingly established, and the measures must satisfy a strict proportionality test. The court must balance the complainant's rights to a private life under Article 8 of the European Convention for Human Rights against Mr. Belfield's Article 10 rights. Based on the oral and written evidence before me, I am satisfied that the orders are necessary and justified. Each of the complainants requires protection from Mr. Belfield. I will explain my reasons. The starting point is my findings in relation to past events. I note that the oral evidence of each of these witnesses was essentially uncontradicted by counter-oral evidence. What the judge is saying is Mr. Belfield refused to take the stand. I also found them wholly honest, impressive, and straightforward witnesses who have achieved substantial successes in their fields. They were profoundly damaged by Mr. Belfield's action, and they have had to seek assistance from medical professionals. Each of them suffered a campaign of harassment by email and social media communications. Each of them suffered serious mental health problems arising from Mr. Belfield's conduct. The longest periods of abuse were suffered by Ms. Breen, Ms. Thomas and Ms. Green. I find that in relation to Ms. Breen and Ms. Thomas, abusive emails running into the thousands were sent over about a 10-year period. In relation to Ms. Green, there were hundreds of emails. In relation to Ms. Hurst, there were not as many emails, but there were highly offensive and transphobic social media posts and videos. I accept the evidence of the complainants that although a relatively small number of emails were produced in court, the policy had been directed to follow was to delete any emails which Mr. Belfield sent. So for those people that are saying, oh, it was only a few emails, the complainants were instructed by the BBC to just delete the emails. That's why they weren't presented in court. In short, they did nothing in response to the barrage of communications, yet he continued to target and harass them over long periods of time. I have not overlooked the fact that in many communications Mr. Belfield was, aside from abuse, also making points on matters of public interest, such as BBC use of resources and listening figures, as well as concerns about content. However, in his communications concerning these complainants, he went far beyond that. His communications were often made to mass email audiences within the BBC, many of whom had nothing to do with the complainants. On occasions, he made highly offensive and personal comments about their physical appearance, including sexualized comments about them. The emails were often blind copied to them. I accept the evidence that Mr. Belfield effectively followed these women by online harassment throughout their careers. Most distressing was the fact that many years after Mr. Belfield had ceased to have anything to do with them professionally, he would email very senior personnel in the BBC with wholly false allegations that Ms. Breen, Ms. Thomas and Ms. Green had bullied him. There was no escape from for these complainants, Mr. Belfield, until the Nottinghamshire Police became involved in late 2020 and bail conditions prohibited contact or references to these persons were imposed. In each of these cases, it was essentially a personal campaign of revenge, which motivated him, as opposed to some sort of journalistic exercise of holding people within the BBC to account. Applying the civil standard, I find that Mr. Belfield carried out a historic course of conduct against each complainant, which amounted to statutory harassment, causing distress and alarm, and that he ought to have known his actions amounted to harassment. I also find that based on the nature and extent of that conduct, on his police interviews and the nature of his defence in this trial, that there is a very substantial risk that, absent a court restraint, he is likely to continue such behaviour. As regards each of the persons, Mr. Belfield is, until further order, prohibited from contacting or attempting to contact the complainants by any means, whether direct or indirect. He must not publish through any form of publication or electronic communication any statement or other material relating to or purporting to relate to them. He must not monitor the use by any of them of the internet, email, or any other form of electronic communication. Any breach of these orders is a serious criminal offence, with substantial criminal penalties, which may include imprisonment of up to 5 years. Mr. Belfield will be given a written record of the terms of the orders. If for any reason the orders are no longer necessary and appropriate, then either Mr. Belfield or the complainants may apply to the court for them to be amended or removed. But until that time, which may never come, they will remain in force and must be complied with to the letter. Finally, I record that I consider each of these women acted with substantial courage and real fortitude in coming to court to give evidence in a public forum about matters which had very substantial negative mental health impacts upon them over several years. The court's orders today are intended to provide them with protection, with criminal penalties for breach against any repetition in the future of such conduct. Finally, I turn to my judgment on the Crown's application for restraining orders in relation to those complainants where the jury acquitted you. Again, you do not oppose that application. This is the judge talking straight to Mr. Belfield. But I need to be satisfied that it is appropriate for me to make the orders and to give reasons for my decisions. So for those that believe there's only 4 restraining orders in place, there are 8. And each of those restraining orders, if breached, carries up to 5 years in prison. So young Alex is not going to come out and mention any of the complainants in the court case in any way, shape or form, because to do so is in breach of a judge's order, which carries 5 years. Chokey. So please, I'm not confusing you with facts. I know your mind is possibly made up, but you need to understand these weren't hurty words. And stop the YouTube whispers. They benefit no one, including your Lord and Master, who's in jail for another 2.5 years. My name's Adrian Allen. Thank you for your likes, your subscriptions, but most of all your indulgence. Don't forget to ding that bell. More videos coming. I will see you in the next video.